How's everybody doing out there? Okay, good to see you again, sort of. I hope the last couple of weeks, though stressful and a lot of work, have been a little more productive after we were together a few weeks ago. I hope you're feeling a little more confident on your retention and recitation of law. That's a work in progress every single day, of course, but just put the blinders on and grind through it. Just grind through it. You're going to get there. A couple more a day really, really will make a difference. Okay, so all is good. Today, we're going to talk more about the actual reading of the questions. I know all the law, John. I rehab myself with the law. I feel much better with the law. I fixed a couple of topics. That all is good, but I can still get it down to two. I'm still overanalyzing. I'm still not getting the percentages I think I should be in some of these subjects. So we're going to talk about common mistakes, actually walking through a handful of questions, showing you some tips that I recommend to hopefully make you a little more consistent with your reading. And a couple of things I always talk about. Not just did you get the question right, but do you know why you chose A? Do you know why B, C, and D are wrong? This is huge because you're still going to have to make some educated guesses on the day of the test. There's still hypos you've never seen before. So sometimes you're going to feel a little bit of that indecisiveness, a little bit of that hesitation. And that's where you want to say, okay, wait a minute. Can I default to some sort of approach? Can I hang my hat on something? I just don't want to go eeny, meeny, miny, mo, or this looks like the one I did last week. I'm going to go with A. This is all ridiculous for all the work you're putting in. So let's talk broad strokes about some overall approach strategies, do's and don'ts, and then we'll walk through a couple of questions together. Okay? So I know many of you were taught, trained by habit. Let me look at the call of the question. That's the first place you look. Okay? You can. There's nothing wrong with it. But as I'm sure many of you are seeing and experiencing over the last several hundred questions or more, the tort question most of the time is going to say, John sues Bob for his damages. Will he prevail? John has a broken leg. Can he recover? That tells you it may be a tort, but it doesn't tell you what tort. Most con law questions will say, is the statute constitutional? The evidence question is going to say, is it admissible? So the call may certainly tell you the name of the topic, but it's not necessarily going to talk about the rule. That's what I talk about, issue spotting. The first thing you need to know on every single question is, what's the issue? What tort? What crime? What amendment? What rule? Sometimes they tell you in the call. In many crim law questions, it says, if charged with burglary, will John be guilty? If charged with murder, will John be guilty? Okay, now I know the name of the crime. But you also know what's going to happen. Now there's two answers say guilty and two that say not guilty. If you don't know whether I did it or not, you're still just going down to the answers, going eeny, meeny, miny, mo. So what are you saying, John? I shouldn't look at the call? I didn't say that at all. I said, if you like to look at the call, go ahead and do so. Even if it tells you the name of the rule, you don't know whether I'm liable, guilty, or it's admissible unless you read the most important part of the hypo, which is the facts. If it just says A sues B for damages, you certainly don't know what the issue is. How will you know what tort? The facts will tell you. The fact pattern is the most important part of every question. It's the most neglected because everybody reads too fast. They're afraid of time. What's this? Let me see the right answer. Slow down in the facts. What's my mantra? Then you'll know what you're looking for. The three things you want to make sure you know before you ever look at the answer choices. What's the issue? What is that rule? And what do the facts say? If you know what tort and you know the definition of that tort and you know whether I'm liable or not, now you know what answer to be looking for. With me? Now that may take an extra 40 seconds, but why do people have a time problem? Most of the time problem, most, not all, but most, is reading so fast or looking at the call and then looking at the answers and not knowing what you're looking for. That makes you reread 3 times. Now you have a time problem. You stare at 2 answers for 4 minutes. Now you have a time problem. If you take more time up in the facts and you process what the facts say, even if it took you a minute and a half, you're still going to know what you're looking for and you'll be done before the 1.8 minutes. This is the thing. Remember, too, I'm always yelling. This is a test of getting more questions correct, not being the first one in the room done. It's not a speed test. Even if, God forbid, you don't get to the last 2 or 3, it's not going to happen. But if it did, even if you don't get to the last few, if you got more of the first 97 right, by definition, you've already passed. You're just trying to get more questions correct. So don't worry about flying through the first 100 and then make 25 reading mistakes. Now you're going to be in trouble. Get more right by being a little more careful. If you know what you're looking for, if you know the issue, you know what the facts say. Now, what's the key? The key is not to say, is it yes or no, guilty, not guilty? What's the best answer? No. My version is, what is each answer about? Every single answer choice on the bar, all 800 of them that you're going to read, are going to give you either elements in plain English or legalese, pieces of your issue, a different issue, or total garbage. Your crime, a different crime, total garbage. What's your goal? Every answer you bubble in must be the most specific answer to what the issue is. If you're doing a negligence question, your answer better be about why I wasn't negligent, not negligence per se, a strict liability. If you're doing a murder question, can't pick an answer about manslaughter. You're doing a equal protection question, can't pick an answer about due process. That sounds so obvious, John. Why would I do that? Because most of you didn't spot the issue in the first place because it didn't tell you in the call, or you maybe read too fast. You mean to tell me, John, that if I know the issue and what's going to happen, I should be able to recognize that answer pretty clearly? Yes. And you should know why the other answers are wrong. What's going on in those answers? The other answers, the wrong ones, can be legally and factually true. Hundreds of answer choices on the bar are legally and factually correct statements of law or fact. The reason they're not the correct answer is because they have nothing to do with the issue. Quick hypo. If you're doing a contract question and it says John sues Bob for damages based on breach, who will prevail? A, John, if there was insufficient consideration. Oh yeah, because if there was no consideration, John, there'd be no contract, right? The consideration answer always makes sense. There's nothing wrong with it. But if the question's about third-party beneficiary, who gives a bleep about consideration? You with me? Hundreds of answer choices are technically true. The reason they're incorrect is they have nothing to do with the issue. My way of saying this is you're basically playing a game of connect the dots. Whatever the issue is, you're looking for the most specific answer based on that issue. Other answers may come to the same conclusion, may be legally and factually true, but they're not specific to what that hypo was about. Even if you have no idea what the question is about. I've never seen this before, never heard of a law. I don't even know the law, John. Every one of you from graduating law school can say, basically, that paragraph was about X, the guy on the bus, the woman on the train. He did that thing over there with that thing. Whatever the thing is, you can always dumb down a fact pattern. And when you do that, what can you now know? Whatever I dumb down that fact pattern to be, my answer has to be about that. That's it. If you're going to shut up and pick by making a good guess, make sure the answer you're picking at least was the most specific to the facts. I'll make you a challenge. If you walk out of that room on that Wednesday and you can honestly look yourself in the mirror and say, every answer I bubbled in, whether I absolutely knew it or not, was the most specific answer to what the facts said, not what you think, but what the facts said, I know you're going to have enough points to pass. Should we try a few and play it out? Let's try a few. So we're going to look at a first question together, tort question, okay? Stay with me, okay? Don't run to the answers already. I know you. Stay with me, okay? Again, if you like to look at the call first, then go take a look. In a suit against a man, is the neighbor likely to prevail? Nothing. Doesn't tell you anything. You got your two no's and your two yeses. Doesn't tell you a thing. Now, if you are that person who hates multiple choice, insecure, some of you may have taken this exam a couple times, took the LSAT a couple times, you just don't like multiple choice. Okay, then yes, I recommend that you read the question from the top down, from the facts first, then the call. Why? Because that forces your attention on the most important part of the question, which is the fact pattern. Just saying. You like to look at the call? Go ahead. But when you look at the call of that question, if it doesn't tell you anything, don't look at the answers because you don't know what you're looking for. Go back to the facts. Do me a favor, don't look at the answers. Take a moment, which I'll give you, and just read the little paragraph. Okay? A dog injures somebody. Is the neighbor likely to prevail in a suit against a man? I'm doing a tort question, got to be a tort, and the dog injures somebody. What tort should I be thinking? Issue spotting, issue spotting. What's the issue? What's the issue? Strict liability. If an animal injures somebody, it's got to be a strict liability question. Rule. Normally, is a dog a wild animal? No. Can a dog become a wild animal? Yes. If the dog has dangerous propensities. Facts. Is this a bad dog? Yes. It says it's ferocious. Then it probably is strict liability. You with me? It doesn't say strict liability anywhere on that hypo. It doesn't say wild animal. Reading comp, issue spotting. A dog injures someone. No, a dog's not a wild animal. Oh, but it could be. That's the dangerous thing. Yeah, it told me this was a bad dog. So it's got to be strict liability. But is that where the question ends? No. I'm always talking about never pick an answer about a defense to a rule or an exception to a rule unless you're sure that's what the facts are talking about. Is this an example of that? Yes, because what did the guy do? He read a sign and he understood what he was going to do and he did it anyway. That's called assumption of the risk. Assumption of the risk is a legal defense to strict liability, only if it's applicable to the facts. Is it here? Yes. So notice, nowhere in the call, nowhere in the fact pattern did it say the words strict liability, wild animal, or assumption of the risk. That's issue spotting. That's what 3 years of law school got you. If you see, okay, so it was a wild animal, but the guy assumed the risk. He's not going to prevail because he assumed the risk. Now I know what I'm looking for, even without all the buzzwords. I'm looking for an answer that basically said no, because he assumed the risk. He read the sign. Now, stay with me. Take a look at A by itself. What does A not say? That he assumed the risk. They don't give you the buzzwordy legalese. But is A what you were looking for in plain English? Yeah. Take a look at B. Trespass. That's interesting. If I was doing an essay on this, could I argue trespass as a claim you would make? Yeah. But what the bleep does trespass have to do with strict liability? Nothing. Right conclusion, wrong issue. Notice the two no's. One's talking about assumption of the risk, one's talking about trespass. The two answers that come to the same conclusion, guilty, not guilty, whatever it is, two that come to the same conclusion will always be defining and discussing different issues. Take a look at C. Invitee, invitee. When do I talk about an invitee? What is answer choice C about? Invitee, licensee, that's about the duty of care. When do I care about the duty of care? Negligence. Invitee, that's a negligence answer. Why do I care about a negligence answer if I'm doing a question about strict liability, assumption of the risk? D. Well, there's one version of strict liability. Notice that B, C, and D all had nice, juicy buzzwords. What was the most specific answer to the facts? A, the only one without the buzzwords. Most people will look for the answer that says assumption of the risk. If it doesn't give you the buzzword that's on your flashcard, I thought it was A, but I guess it's not because I don't like it, so I'll go with D. That's the closest thing I can come to with strict liability. That's why people fail even though they know the law. What answer matches the question? A, assumption of the risk, though it never mentioned the buzzwords. Sometimes they give you the buzzwords, sometimes they don't. What's a takeaway from this? The call didn't tell you anything, but I got all my information from the facts. So if you find yourself staring at a couple of answers, A, if you got it down to the two, A and D, well, I thought it was assumption of the risk, but D looks like a better definitional thing for strict liability. If you get it down to two and you know what your issue is, can they give you two larceny answers, two hearsay answers? They always will. Two strict liability answers. If they give you two, they will always come to opposite conclusions. Yes, no, guilty, not guilty. If you're staring at these two, all you got to do is go back to the facts and it'll tell you whether he's going to win or not, whether it's guilty or not. If you're getting it down to the two no's, these two no's were literally defining different torts. C and D, the two yes answers. One was talking about negligence, one was talking about strict liability. Each answer is about something. Connect the dots. I go into the answers looking for something that talks about no, because he read the sign, that's assumption of the risk. And that's exactly what A was talking about. So the call didn't help you. The correct answer was not in the legalese, but you knew what you were looking for. And what do you do when you know what you're looking for? Shut up and pick it and get the hell out. But I know why B, C, and D are wrong. I know that because I know what those buzzwords are referring to. So again, quickly before we do the next one. If you get it wrong and you forgot what invitee is, you forgot abnormally dangerous activity, you forgot that assumption of the risk is a defense, that's a law problem. Hey, I forgot the rule because it would give you the explanation. The first two lines I said last time, in the first two lines of the explanation, you should know whether you forgot the law or not. If you did, then go put the law back in your head immediately and constantly walk around the house for the next week saying for the 3 seconds it takes, strict liability, wild animals, abnormally dangerous activity. So it doesn't fall out again. And the next time you get a question like this, you'll get it right. If you knew the law, okay, then it was the reading. Either A, you read the question and said, is the neighbor likely to prevail? I don't think so. Let me look. Don't litigate it here and come up with your own personal conclusion, and all of a sudden you're pigeonholing yourself into a bad answer. Or even if you thought you were, even if you were correct that you got it down to the nose, there's still a huge difference between the two no's. And you'd only know which no to pick if you read the facts. The fact pattern is the most important part of every question. Be honest with yourself. If you forgot the rule, fine. If you knew the rule, then focus on the reading comp. Don't go in the answers until you know what you're looking for, and then you connect those dots and always pick the most specific. Not the best argument, not the one with the best buzzwords, but the most specific to the facts. Let's take a look at the next one. Property. Ugh, terrible, John. Don't worry about it, okay? So here, if you like to look at the call, you can see, is the man liable to the bank for the deficiency? That kind of refers to the rule, okay, but you don't have enough information to go no, no, yes, yes, okay? Definitional stuff, don't worry about it. Big numbers, it's actually a basic definitional question. Take a look at the fact pattern, please. Okay. By the way, I think there was a question in the chat there. The correct answer to the last one was A. The plain English definition, basically, of assumption of the risk. Okay. And yes, when it says what's the strongest argument, what's the best concept to prevail, all of that is garbage. What they're really asking you is what happened in the facts. When it says what's the most serious crime John could be guilty of, that really means what did I do from the facts? Don't go in the answers and try to compare and contrast the answers. You focus on what the facts say, not what you think. So in this one, okay, basic mortgage question. The woman borrowed the money, correct? She owed the money and she sold it to the guy, correct? Yes. What specifically does it say? When someone buys land and there's a mortgage on the property, the buyer either buys the land subject to the mortgage or they assume the mortgage. If you assume the mortgage, you assume all the rights and obligations. You become primarily liable. If you don't pay, can the original person be secondarily liable? Yes. What's the default rule? You generally buy land subject to the mortgage. It's your property, but you have no financial responsibility. How will you know if the guy assumed the mortgage? They will tell you. Did the guy, the buyer, the man, did he assume the mortgage? Yes, it told you right there in the first paragraph, and specifically assumed the mortgage note. Correct? Correct. Without informing the man, the bank later released the woman from any liability. Okay, so she's off the hook. So now it would fall clearly on the man. Now, the man's already primarily liable. That's just to tell you that she's no longer liable secondarily, right? After he owned it, he defaulted, the bank accelerated, and all kinds of garbage happened. Even if you didn't understand that stuff, is the man liable to the bank? Is the guy on the hook? Is he responsible for the mortgage? Yes, for the amount. Why? Because he assumed. And you know that he assumed the mortgage because the facts told you. So again, you don't like numbers and you skimmed and you looked at the call, let me look at the answers. You'd be looking at four weird concepts and you wouldn't know what you're looking for. You stick to the basic definition. Someone buys land and there's a mortgage on the land. He either assumes the mortgage or he takes subject to the mortgage. They'll tell me. So is the man liable? Yeah, he's going to be liable because why? Because he assumed the mortgage. He's personally liable. We'll go to the two yeses first and then we'll do all of them. Take a look at C. Yes, because the bank's release of the woman constituted clogging of the equity of redemption. I don't think that's right, John, but my mind is clogged, but that's as much as I can figure out. D. Yes, because the man's personal liability was not affected by the bank's release of the woman. Isn't that basically what the facts just said? That the woman was released, but the guy is on the hook because he assumed the mortgage. Take a look at A. No, because the woman would still have been primarily liable, but the bank had released her from personal liability. But that is an answer about the woman, not the man. It doesn't answer the question specifically. He assumed, so he is responsible. B, no, because the bank's release of the woman from personal liability also released the man. That's just not legally even true. So again, if I know the basic rule, if you assume the mortgage, you're personally responsible. The original person could be secondarily, but either way, you're on the hook. If I knew that from this fact pattern, because I caught the one word in the top of the first paragraph, specifically assume the mortgage note. I say every day, one word can change most of these hypos. That previous one, the dog was ferocious. Now I know it's a wild animal. Slow down in the facts so I know what I'm looking for. And if you spent an extra 40 seconds in this hypo, now you would know exactly what answer to pick. Answer choice is D, delicious, because you knew what you were looking for. If you forgot the difference between assumed versus subject to, I didn't see that, John. My bad. Okay, go back into the notes. You memorize the rule. Take your $100 highlighter that you all have. Highlight the little set. Oh, yeah, assume the mortgage. He's right. They would have told me. So he's personally responsible. Once I see it, now I'll never miss it. Don't be afraid of the mistakes you're making now. As long as you can study the hypo, learn, oh, that's the word. That's what I should have seen. And you kind of take that mental screenshot of it, flag them, star them, sit on your couch on the weekend and review some of these reading mistakes. And all of a sudden, you're going to peak by the time we get to the bar. What's the key again here? They didn't name the rule. Is it true that he assumed the mortgage? But you know from the facts, and I know what answer I'm looking for. D, delicious. Let's take a look at the next one. Okay? Okay, so here we got our criminal law. All right, so here, stay with me. Stay with me. So again, take a look. The president was convicted of murder. On appeal, he argues his conviction should be reversed. So, murder. They're telling you, okay? The first two didn't, but this one told a murder. Got to be murder, John. Okay. Now, what didn't they tell you in the call? How many murders are there? At common law, how many definitions of murder? Four. Intent to kill, intent to inflict serious bodily harm, felony murder, depraved heart murder. And how do you act under depraved heart? Reckless disregard of human life, recklessly. So once they make that question about murder, what have I said? Your answer has to be about one of the murders. Connect the dots. You with me? Take a look at the facts. Okay? So he kind of put it out there, even though there was some concern about what was going to happen, right? Which one of the four is that really talking about? I always thought this was a quote tricky question. It wasn't very specific in the facts. Even if you had your ideas, what am I trying to get across from this exercise? Once I know the issue, my answer must be about that issue. They made the question about murder. It's got to be about one of the four. Concerned about being able to fulfill the contractual requirement. He da, 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 da. So It was kind of out there, but let's see. I go into the answers looking for something to do with the four murders. Let's take a look at A by itself. Strict criminal liability. Does strict criminal liability have anything to do with any of the murders? No. B. What good word is in B? Reckless. That's a murder answer. C. Regulatory offense. What the bleep does that have to do with murder? Nothing. D. Now, this is what trips up so many people. Proximate cause, John. Proximate cause. When do I care about something with proximate cause? What is proximate cause an element of? Negligence. And when do you care about negligent conduct causing a death? What definition is that when negligent conduct causes a death? Involuntary manslaughter. Involuntary manslaughter. Any answer about duty, breach, foreseeability, causation, that's a negligency answer, and negligence and death mean involuntary manslaughter. So B and D, you could have gotten it down to B and D, all right? A and C are not talking about anything. Get them the hell out of there. B and D, reckless, negligent. This is the ultimate. You can get four more questions right easily if you keep this stuff separate. Negligence and death, manslaughter. Recklessness, depraved heart murder. Therefore, be beautiful is the correct answer. If you got it down to those two, is this a murder question or a manslaughter question? Not the best one, not the most serious one. They made it a murder question. Your answer has to be about one of the four murders. Connect the dots. Be beautiful is the correct answer. Got it? Good. Anything to do with negligence, duty, foreseeability, proximate cause, any of the negligency language, that is an involuntary manslaughter answer because that's a definition of involuntary manslaughter. Negligent conduct causing a death. And that's how you contrast it from B, which is the murder answer, depraved heart murder. Got it? Connect the dots, spot the issue. If you didn't recognize this as a murder question, you wouldn't have had any chance. That's number one. You saw it as a murder question, but don't you have to always be the proximate cause, John? That's some legalese garbage. You want to say what is each answer about? And anything to do with negligence, that's manslaughter. Anything to do with reckless, that is murder. Connect the dots. So again, you could have got it down to B and D. If you forgot which one is reckless versus negligent, which is another email I get all day long. Okay, that's a law problem. Forget more crim law questions. You need to go back and put those rules in your head, and then you see how easy it is to see B and how D is dumb. That's the point. So again, I'm always screaming. If you see, oh, I forgot the reckless negligent. Yeah, that happened to me, John. Okay, no problem. Put it back in your head. You'll never make the mistake again. And look how obvious the difference in the answers are now. Issue spotting, reading comp. Here they told you it was murder, but you still needed the facts to know which one of the four. Let's do the next one. Con law. So here you go. Is the law constitutional? Gee whiz, John, that helps. That's my point. So if you now go into these answers, you're going to be reading a lot of gobbledygook about a lot of stuff. You don't want to read four. You want to know going in, what is it all about? Take a look at the facts, please. So again, here's my example. Is the law constitutional? I got to know the specific issue. What's the issue in this question? Okay, what's happening? I always say, when they give you a law or a statute, state, federal, sometimes both, what is the government doing? Issue spotting. What is the government doing? What is the law about? Dumb everything down into plain English and you talk yourself into the correct issue. You with me? Don't think, oh, what could it be? What does it say? What is this about? Displaying posters and campaign literature. Speech, right? Displaying stuff, posters, literature, anything like that. Is the law allowing the barbershop to put some of it out, to put some of it out in a certain location, in certain places in the barbershop at certain times, or are they saying you just can't do it? You just can't do it. If there's a law that you can't do any form of expression, is that content based or content neutral? Content based, because content based is you're just shutting the whole message down. Content neutral is, well, you can't do it here, but you can do it there. The so-called time, place, and manner restriction. You couldn't do it in this, but you couldn't do these posters, but you can do other posters. They're not telling you you can't, they're just telling you where, when, and how. So this law always start with speech. Is it content based versus content neutral? There are particular rules, you know, about unprotected speech and obscenity and public forum. There are very particular hypos, but broadly speaking, anything about First Amendment, first thing you want to do is say, is this content based or content neutral? That's what most of the questions are about. So once I see the law prohibits all, you can't do it, I know that's content based. And what does content based trigger? Strict scrutiny. What does content neutral trigger? A more intermediate version. But if I see here that nothing can be distributed, nothing can be expressed, there's no form of expression that's allowed, immediately I know that's content-based, which would trigger strict scrutiny. Now, they can take this hypo and do the same exact hypo, but at the very end of the sentence, it could say, but they were able to do it in certain places. Again, that's why I'm always yelling. At this time of year in all of February, you're going to have done so many questions that many of these hypos begin to look the same. In fact, many of them are the same, but with little tiny nuanced modifications. People yell at me all, oh, that's a tricky question, John. Well, it's not tricky. It's just you didn't pay close enough attention to the facts. Okay? They can test you on little nuances of law that a lot of people don't know. That's their fault. You don't worry about those questions. You take responsibility for the ones you missed because the next one you do that looks like this will look like content based, but they'll change the hypo ever so slightly. That's why you put all your eggs in the fact basket and make sure you know which version they gave you so you know what answer to be looking for. This is content based because they didn't let anything. Now take a look at answer choice A. No. B. Does that look good? Compelling state interest refers to strict scrutiny. Exactly. Compelling interest, strict scrutiny. Content. C. D. How many answers are even remotely on point to content-based strict scrutiny? One. Many of these answers, just like the one with crim law, okay? Many of these answers, there's only one answer on point. The reason you don't recognize that as often as you want to is because you possibly either looked at the call and went to the answer, skimmed the facts and went to the answer, and you didn't know what you were looking for. Look how irrelevant the other answers look if you know that it's all about content-based and strict scrutiny. Now, again, if you thought content-based, but you forgot compelling state interest was the definition of strict scrutiny, okay, then you go back to your notes and you put it back in your head and say, okay, now I know what it looks like. I'll never make this mistake ever again. Got it? There's a quick question here. Why not equal protection here? Because equal protection is treating people differently, singling out groups of people. This is about the display of the posters, about no other kind of posters or literature can be distributed. That has nothing to do with treating people differently. They're talking about what can be displayed in terms of posters and literature. You could, on many of these questions, be thinking, hey, couldn't it be this? Couldn't it be this? Couldn't it be? And if you're writing an essay on this, you clearly could go in a couple different directions. That's not wrong, but that's why I'm always talking about what's the issue. After enough con law questions, you'll know what equal protection looks like. Yeah, it's really about treating those people differently. It's not going to be talking about the display of posters, literature, pictures, placards, and going on marches and demonstrations. So if I'm on the fence, you really then have to throw it at yourself and say, is this really about treating people differently, or is it about the display of the posters and the literature? No, it's about the literature. I got to go with First Amendment. I got to go with speech. You will have that happen to you many times, but when I'm sitting on the fence, that's what you do. Is it really this or is it really that? Not what it could be. What is it talking about? The theme, the thrust of the fact pattern It's really all about the stuff that's being displayed. That's First Amendment, and that's how you stay away from equal protection. Good. And that applies to all the other subjects. You could always make those arguments, but trust always what the facts say. And remember, you're going to be wrong once in a while. Okay. I said last time, I'll say again. You know, rationally and intellectually, you're not getting all these right. But if you read them all the correct way, the right way, you're going to get enough right to pass. That's why I scream all the time about muscle memory. They can get you once in a while, but let them get you on some weird version of it, not because you screwed up the reading. Let's try another one. Okay, civil procedure. Okay. And yes, there was a quick question there, and that's why that's a law thing. You need proximate cause for all crimes. But if under that logic, then every time proximate cause is an answer choice, you'll pick it because it always makes sense. That's the problem with that. That's true. That's like consideration. You need consideration to every contract, but that would mean you'd pick consideration every time it's an answer. I'm giving you specific definitions. Anything regarding negligence, that regards manslaughter versus reckless, which is murder. Keep them separate, focus on the definition. Now, here's another example for Civ Pro. It literally, take a look at the close of the evidence. Both parties move for judgment as a matter of law. How should the court rule on these motions? So they're telling you it's judgment as a matter of law. Okay? They're telling you. But I still need the facts to know what the facts say, because what's judgment as a matter of law about? It's about whether a jury has enough evidence to find for the party. What is the evidence? If I just look at the call and go to the answer choices, I wouldn't know. I'll shut up. You take a look at the little hypo. So you read this and you trust the facts and you go with your common sense, right? The man sued the tavern, right? Did the tavern do anything wrong? Is the tavern negligent? Or is this guy just an idiot? I was an idiot. Tavern didn't do anything wrong. You with me? Tavern didn't do anything wrong. The guy went out. So I say both parties are moving for judgment as a matter of law. Okay? From each person's perspective, you're basically saying a reasonable jury doesn't have enough evidence to find for that guy. Okay, based on that hypo, who's gonna get it? The tavern. Because the tavern's basically going to say, there's not enough evidence to find for that guy. We didn't do anything wrong. Back in torts, one of my pet things to talk about is res ipsa versus negligence. So this you could have looked at either way, because this looks like a negligence question, but I always talk about res ipsa. There's going to be some sort of emotion at the bottom, and what will the court or the judge do? So whether you looked at this as a res ipsa question, because it looks like one, or a civ pro question, judgment is a matter of law, you're basically going to come out in the same place, which is there's no evidence that that the tavern, did anything wrong. This guy was just an idiot. Not enough evidence to find that the tavern did anything wrong. That, based on my reading, is what the facts say and what I was looking for. Got it? Therefore, take a look at answer choice A. So there's your reasonable jurors could conclude. And if you remember, oh, it's about whether the jury has enough evidence. That's an answer that looks good because it has some right language, but is it specific to the facts? No. B. Garbage. C. That looks good, John. That's specific to the facts. D. Garbage. To the rule regarding judgment as a matter of law. You're just asking, does a jury have enough evidence to find for the part? You with me? C is the most specific based on the facts. You look at those answers too quickly, then you get in your head and you're kind of, well, maybe the man was put it. You know what I'm saying? You know how it happens. You make those arguments in your head. The little voice only wants to be speaking, what did the fact pattern say? This guy was an idiot. The tavern didn't do anything wrong. Where's the most specific answer that the tavern didn't do anything wrong? C, shut up and pick it. Again, he says, you saw it was judgment as a matter of law. You could know the rule, hopefully, but you still need the facts to tell you who, if anybody, did something wrong. You always need to go back to the facts, so in turn, you know what you're looking for. Take the extra 30, 40 seconds in the facts, because ultimately then you'll know what you're looking for. This is the key. Got it? If you get the question wrong, is it the rule that you forgot? No problem. Just go put the rule back in your head. If it's the reading, most of the time, you didn't spot the issue. You spotted it and picked an answer about an unrelated issue, or you spotted the issue, you got it down to two, and they come to opposite conclusions. Again, go back to the facts. Always be asking, what is each answer about? Every one of these answers is either about your rule, a different rule, or total garbage, totally irrelevant, at the risk of sounding like a used car salesman. If any of this now makes sense, like, hey, maybe I wasn't reading some of these the right way. Maybe I do need to tweak my approach. Maybe now I'm looking at these questions or the answer choices a little differently. If you need more detail, more specificity, more detail about what I'm saying, there is a video on the video page on AdaptiBar called Mastering the MBE, which is a more detailed version of what we're talking about right now. So if you're starting to think maybe I'm screwing up some of these questions for some of these reading problems, maybe I'm looking at the answers in a wrong way, then that video will certainly help you. I'm just saying that hour and 20 minutes of fixing or tweaking your approach would be better than running and doing 500 questions and still getting most of them wrong for the same reason. Always be thinking, how can I fix the mistake? It's either the rule or it's the reading comprehension. So that video, Mastering the MBE, could definitely give you more detail on how to do that. Someone was also posting a question about, should I do practice tests and finish the bank of questions? Of course, by the end of bar prep, if you ended up doing all the questions, that's great. Is that a goal? No. The question again is accuracy, getting more right. When would I be doing practice tests? And this is again, I know some of you are still in your course, some of you are doing your own thing. That's why I'm always very reluctant, because I'm talking big picture, okay? February, okay? After you've completed all of your subject review, okay? You've done your MBE, I did my 7, took your practice test maybe, or now you want to do, sure. Once February rolls around, I recommend the practice sets in exam mode, i.e., you don't know what the answer is until you review the whole thing. For the next couple days through February, and if some of you need a little more time to fix this reading comp, then go into the first week in February. There's no right or wrong. Just make sure that you're more consistent first, getting more questions correct. Once you feel like, hey, I'm pretty good, and maybe it's on 4 or 5 subjects, not on all 7. Once you feel there's a couple of subjects I'm okay on, then you can go do a small practice set on a day-by-day basis in that exam mode, so you get used to going from one question to the other and not thinking too much about the last mistake. How many times have you done that? 1 or 2 questions could screw up the momentum, right? So during February, I certainly believe in the practice test in exam mode, not 100 a day and 200 on Sunday. No, just because remember, you want to balance your review of the law and you want to balance especially your writing portion. Don't neglect the writing. You have to do the writing and do enough MBE for the balance. Even if you're not taking the writing portion, you can only take the MBE. You don't want to burn out and do. Many people call me and said, I did 4,000 questions on AdaptiBar. I was getting 92%. Yeah, because you did all the questions 3 times. But that doesn't mean you're reading them correctly. Focus on quality, not quantity. You want to take a couple of those practice 100 questions exams on AdaptiBar? Sure, I think you do your studying during the week, and then you want to do one every Saturday or on a Sunday during February as a way of prepping. I think that's a great idea. I think a lot of people overdo the practice tests. And just because what happens when, let me take a practice test. Let me take a practice test. What are you really worried about? The overall number. So what happens when you do that? You fly through the whole test because you want to see what your score is. And then you're depressed because it wasn't as good. Focus on doing smaller sets and getting more consistent, and then do 50 or 100 on a Saturday or a Sunday. And again, though, if you practice slowing down day by day by day, that's what you'll do when you 50 or 100 or 200. Slow reading and being more careful means more questions correct. That is ultimately the goal. So fewer but consistent practice sets during the week, some extra long, a few longer ones on Saturday or Sunday during February. Again, you want to do those 100-question ones, great, but focus on the reading, not the speed, and you're going to be shocked how well you're doing. Issue spotting, what is each answer about? Slow down up here, you're going to go faster in the answer choices. Check out the Mastering the MBE video if you think that can help you and you need more detail about a lot of what I said, because as always, I talk fast. I apologize. I wanted to get through as much as we can. February's almost here. Stay confident, stay aggressive, take responsibility for the rules you still have to flesh out and sharpen up. Just keep reciting and really take responsibility for that good reading comprehension. Be careful. What's the issue? What is the answer about? And when you see the answer, whether it's in plain English or the law, what are you going to do? I'm going to shut up and pick it. Confident and aggressive. Hang in there, and we'll see you soon. Take care.